All right, everyone. Welcome. Thank you for joining us for part 3, the final session of Beyond a Will, How to Secure Your Legacy and Build Generational Wealth through Estate Planning with Legacy Counselor Shakisha Morgan. This is session 3, Securing Your Legacy and Building Generational Wealth. Thank you guys for joining us. My name is Naomi Demsas. I am on the leadership team of the Eritrean Diaspora Network. We are very excited to introduce Shakisha Morgan, our presenter. Before we do that, for those of you new to the Eritrean Diaspora Network, EDIN is a community organization dedicated to the advancement of the Eritrean diaspora through nonpartisan community programming. One of the ways that we do that is through professional development. EDIN has a professional development network, and the primary objective of this program is to promote the spirit of networking and cooperation among Eritreans in the diaspora and help foster their individual and collective success by providing networking opportunities, supporting the development of Eritreans in their given careers through various programming efforts. We are enhancing the awareness of the professional accomplishments of Eritreans within both the Eritrean and broader community, hence our monthly professional spotlights. To date, we've featured over 100 Eritreans in a wide variety of careers. We've also hosted a series of workshops on various topics, including finance, this one specifically on building generational wealth and legacy planning, immigration, and grad school. We've also done a tech series. The Eritrean community always comes together when there's a loss or death in the community to raise funds and to support families. It's the hallmark of our community. However, it's also essential for us to understand proper estate planning and planning to protect assets, to alleviate legal complications, and build generational wealth. This series aims to provide education about the basic tools of estate planning, such as wills, trusts, and power of attorneys. The workshops are also intended to introduce planning issues related to probate, guardianship, titling of assets, community property, and estate taxes. For this event, we are especially excited to partner with the Eritrean American Bar Association. I'll let Rahel tell you a little bit more about the Eritrean American Bar Association.
Thanks, Naomi. Hi, everybody. My name is Rahel Kifle. I'm a board member of the Eritrean American Bar Association, the EABA. We're proud to co-host this event today alongside the Eritrean Diaspora Network. I want to take a moment to publicly thank Shakisha, who's my friend and colleague in the field of law, for presenting this estate planning series. We're really thankful for your time and your generosity in sharing your expertise with us. So some background on the EABA. The EABA is an inclusive professional network of Eritrean American attorneys and law students in the United States. We have a 3-pronged mission. 1, to build a strong professional network to support fellow Eritrean American attorneys in their careers. 2, to motivate and guide Eritrean students in pursuing a career in the legal field. And 3, to empower Eritrean communities with knowledge of their legal rights in the United States. So if you're interested in joining our organization as a member, becoming a mentor or mentee, attending future events, or just supporting in general, please reach out to us on our website. We'll drop it in the chat, but it's www.eritreanaba.org. Again, eritreanaba.org. Drop us a note in our contact form and we will get back to you. Thanks.
Thanks, Rahel. And that's the website right there for everyone. Thank you. Just a couple housekeeping items before we get started. Please keep in mind the mission and values of both organizations and respect this space. There will be an opportunity to ask questions, but please add them to both the Q&A feature, which is kind of right in the bottom, has like a little chat box, or add them to the chat, and we will do our best to track them and make sure they get answered throughout the workshop. If you'd like to ask a question in person, just raise your hand and we'll pop you over, and you can do that as well. If you take pictures and talk about this event and talk about how awesome either EDIN or the Eritrean American Bar Association is, please tag us at Every Diaspora, or check out the Eritrean American Bar Association on their LinkedIn as well. There's a lot of helpful Know Your Rights information available on the website, so please check that out too on the Eritrean American Bar Association. We will be recording the session. And then last but not least, just have fun and, ask the questions that you need to ask. Shakisha, like Rahel said, is incredibly been gracious with her time and has done an awesome job presenting really complicated information in the last 2 sessions. So we encourage you to utilize her right now and ask your questions and ask away. Before we officially begin, we would like to introduce the great presenter, Shakisha Morgan, the Legacy Counselor. Shakisha is a learner, strategist, and connector with over a decade of legal experience. An educator at heart, Shakisha is affectionately known as the Legacy Counselor. She is the principal attorney of the Morgan Law Firm, LLC. She graduated from Stanford University and Georgetown Law School. Shakisha has devoted herself to increasing access to generational wealth through her work, conducting community and corporate workshops, delivering guest lectures and keynotes, and providing transformative advice to her clients. She is a published author on topics related to estate planning, multi-generational wealth building, Black wealth, and servant leadership. Shakisha is a philanthropist and enjoys serving as a mentor and a board member of the Young, Black, and Giving Back Institute. She's a proud daughter of Jamaican immigrants, a ride or die sister, devoted wife, and loving mother of a triumphant toddler. Outside of her career that she adores, you can find Shakisha co-hosting the Mary and Martha podcast, where she encourages Black women to live impactful lives of faith. We will put a link in the website chat to Shakisha's website. She is available to help you with your estate planning needs if you live in the DM area, DC or Maryland. So here's that website right there. So please check her out. With that said, let's jump into our workshop. Shakisha, take it away.
Thank you so much. All right, everybody. This is our third weekend together, our third and final weekend together. So I just want to start by saying thank you to the Eritrean Diaspora Network and the Eritrean American Bar Association for having me. It has been a blast. So let's get right to it, because I don't like to waste time, and we've had a good time together. So let's continue the party. Today, we're talking about legacy and wealth building. And so the big idea, right, is that people want to know, well, how do I create wealth for me, for my family? How do I protect it? And that's what we're going to talk about today. The reason why I have this subtopic where we're creating generational wealth through informed decision making is because what we've been doing these last Saturdays has been sharing information, having a conversation about the things that matter and the things that we need to know when we're making smart decisions related to this. And so we're going to continue that today, but we're going to start with a little bit of a review with all that we've been talking about. So if you haven't been here for all of the sessions, I'm sorry, you missed out. We've been having a good time. And here's what you missed. First, we started with a modern understanding of wealth, right? So we talked about the traditional understanding of wealth, which is just money, houses, the things. But we actually talked about a more modern understanding of wealth, where we're not just thinking about passing on money, passing on houses. We are thinking about those things, but we're not limiting ourselves to that. We're also thinking about passing on family traditions. We're also thinking about passing on family wealth. I follow this entrepreneur named Myleek on Instagram, and one of the things that she had said within the last week, I think it was, is that she mentioned that when we talk about generational wealth, let's also talk about generational healing. And I was just like, let's talk about it, can we? Right? Because it's not just about what we're giving our kids in terms of money and property, but if we're really talking about maintaining and building upon what the last generation did, then we need to be having conversations about how we raise our kids. We need to be having conversations about how we want to be involved in community. What does community look like? We need to be involved about having conversations about financial literacy, legal literacy. Do we know our rights? So I was so glad that Naomi mentioned that. I hope that you guys check out those tools and those resources that are available to you. We also talked about the importance of estate planning, and we talked about the 3 big things that estate planning brings together. Number 1, in no particular order, estate planning brings control back to you. So one of the things that families of people who have passed or people who are sick is that they don't know what's supposed to happen. Well, while you have the ability to make those decisions, to know who has good decision-making ability, to know who has good financial acumen, to know who has good discretion, make decisions that are going to propel your ideas about wealth and ideas about health and ideas about responsibility forward. Secondly, it brings together community. So we're thinking about the people that we trust. We're thinking about the people that we know we can rely on. And we're thinking about people's limitations as well, and making decisions about those that we trust to do the right thing and to do the right thing according to our own values, and putting them in the place to be able to do that. And then we talked about the fact that estate planning brings clarity, so that people are not confused about what to do. People are not confused by the court processes that happen when we are not prepared for things. And so estate planning brings control, community, and clarity back to you and your loved ones. And so it's important to understand that is the reason why it is so powerful. We talked about legal tools for wealth creation. So we talked about powers of attorneys. Well, in the first session, we just went over some of the different tools, but in this last session, we went and did a deeper dive into powers of attorneys to avoid guardianship, which is that court process that happens when someone loses the ability to manage their things. People have to find a way to help them out. We talked about Britney Spears. We talked about the drama that can come with that for families, and grief that is happening when people are sick. And so we talked about how we use powers of attorney to avoid that, right? We talked about legal and financial power of attorneys. We talked about medical powers of attorneys, living wills, those kind of things. We talked about passing down property in the very first session. We talked about how important it is to pass down property at death, not to just write your kids' names on your deeds and think that you have done a good thing, but actually when we're thinking about avoiding unnecessary taxes and tax implications and complexity when it comes to the court process, to do it the right way. And then we touched on wills, trusts, and business succession planning, which are all used to avoid probate in one way or another. And today we're really going to get into those three. And then finally, we talked about important considerations for wealth. What do you want to do? How do you want to live? Who do you want to be around? Who do you want advising you? What are going to be some of the important decisions that you're going to make? All of that goes into good estate planning. And so today we're going to jump and deep dive into the legacy side after we have passed. And I know that's crazy, right? That the world would lose people as wonderful as all of us. But the reality is we can't avoid the truth. And the only truth in this world is that at some point we will pass on. Right? It's the only thing that we all can count on. And I say that as a person of faith, but it is one of those things that what is equalizing across the board, whatever you believe in, whatever you retrieve in, whatever you do, at some point we're all going to transition. And it's important for us to be prepared for that reality and to prepare in such a way that helps us to gift our loved ones, make that last gift to our loved ones that says, we did good planning because we love you that much. All right, y'all ready to get into it? It was a good review. Did I miss anything?
No, you didn't. But you know what, Keisha, I meant to ask you this last week and I didn't. But in terms of cost, right? I know like what would an attorney cost for you to actually properly do your estate planning? And then what would the cost be like going through the probate process in court? Like what's the cost benefit of each or the other?
That's a
I
really
feel like you answered it before, but I just wanted to get some numbers.
Yeah, I did touch on it the last session. We did touch on it, but I think I'm going to hold off on that question only because I'm about to explain the probate process.
Great.
So it's going to be important that before I tell everybody what it costs, you have to know what it includes. Okay. Because the only cost for probate is not just the money part. It's also the time and opportunity that's lost through the probate process. So that's a great segue. So let's talk about wills and probate. And the reason why I'm talking about wills and probate together is because a lot of people have this idea that if you have a will, your stuff is not going through probate. And that is simply not true. A will is actually a legal document that guides the management of your estate through the probate process. So if you right now either don't have any estate planning documents, or the only post-death documents you have in your estate plan is a will, your estate is likely to go through probate. And what does that mean? Probate is a legal process. Remember last time we talked about guardianship? Guardianship was the lifetime legal process. Somebody gets sick, you need to manage stuff for them, and so you're going to go through the guardianship process. Well, probate is the post-death legal process. So for those of you who, so some of you may unfortunately be familiar with the probate process because someone passed and you had to take care of things. But probate occurs when there is something in someone's name, titled in their name, a car in their name, a bank account in their name, a house in their name, and you need legal authority to take it out of the person who passed name and give it to whoever is their beneficiary. Now, if there is no will, the beneficiary is determined by the state. They have a list that they go through. Every state has a priority list. Who benefits from your estate if you don't make the decision about who benefits? Now, the probate process includes selecting a personal representative or an executor. I'm going to pause here because unless you are a family with one kid, that means that if there are multiple adults in your family, who can be the personal representative or the executor, depending on where you are, they mean the same thing, but they are just called different things in different areas. But if you have more than one adult who can be the personal representative, then that's a point of decision making. And I have been in probate situations where multiple people want to be the personal representative, especially in blended families, especially in families where one sibling, even though they may not be the oldest, they think that the one that's most responsible, or situations where the sibling who might be the oldest is not the one who took care of the parents in their final days while they were sick, or just in family structures where there is some broken relationship. And it doesn't have to be fully broken, but it could just not be a strong relationship. And all you need is more than one person to decide that they think that they should be the one that makes the decisions for the estate for there to now be a hearing, right? So you could have a hearing before anything even happens related to the court process, because there has to be a decision on who manages the court process. If you have a will, you can name who manages the court process. Now, if you have a will and you go, well, I have 2 children, they're great, I'll just name them both as personal representatives. I hope you're not intending to work with me, because I'm not letting you do that. Because if you have more than one person, then you have confusion. Now, if you want to do one person, then another, we can do succession, but we're not going to have 2 people serve at the same time. Why? You like to hear a story? Of course you'd love to. So here it goes. There were these 2 brothers and their mother passed. The older brother was the responsible brother. The younger brother was not. They were both listed by the mother as a personal representative. She had not been one of my clients. The older brother came to my firm because he wanted to sue the younger brother because he took money out of their mother's account after she passed, because he needed money to pay for certain things. So there's 2 things that happened there. One, she named them both, which meant that both of them had decision-making authority when she knew that they didn't have a good relationship, because he told me they hadn't been good since they were teenagers. But mama just decided, well, I got 2 sons, so they can both do it. They'll work it out. I hate that. People, they'll work it out. My family will do what's right. Okay. Sure. Okay. We can believe that, and then we'll be in court. Okay. Secondly, the mother had named her sons as co-owners on her account to avoid the probate process. But because everybody was a co-owner, that doesn't mean that everybody split what was in the account. That means that every single person had the right to take everything in the account. So I had to tell the older brother who came to me, that there was no remedy. There was no legal remedy on his side, because his brother is co-owner of the account. Even though he emptied it, he had the right to, because he was an owner. And that was a choice that his mother made. And I can't tell you how hard conversations like that are. Don't leave your people to have to talk to somebody like me and have those hard conversations. Let's make good decisions, informed decision making. So that's just the very first step. Probate requires someone to be named to manage the estate. If you have a will, you can name that person. Number two is that depending on what jurisdiction you live in, there may be something called bond. Bond is an insurance policy. And it is an insurance policy because what people like to do is some people will get authority to manage an estate, take all the money and run away. So they get bonded such that if they end up running away with the money, the insurance company will pay out to the beneficiaries. And then they're responsible for finding the personal representative to get paid back. What does that mean? It's one of those things that's not really talked about and you don't find out till later. If you are in the great state of Maryland, as an example, when probate happens, if there needs to be someone bonded for the estate, the court now has made the decision, or not the court, but insurance companies are now making the decision that they won't bond someone until they hire a lawyer. Now, in your will, you can waive bond, but if you don't have a will, and even if it's somebody you love and trust that goes to be your personal representative, if there needs to be bond, they are now required to hire a lawyer. And at that point, they're now $2,500 to $4,500 out of money once you have to hire an attorney. So do you see, Naomi, why I couldn't answer your question immediately? It, like, the money can stack and we haven't even done anything yet. Nothing has happened. You haven't paid any fees to the court yet. You just had to go hire an attorney so you could get bonded, so you could manage the estate of your loved one that passed. You haven't even done any work yet, right? Okay, so you get bonded. Another thing, if you have kids who are under the age of 18 when you pass, successor guardians have to be named. That is the place that your will and only your will can do that. So you name that. If you don't do that, remember that guardianship process we talked about during lifetime, it happens after, so that your kids can get someone named. That's if a family member steps up. And if not, then they go into the system. And then your money goes into the guardianship court to be held until they're 18 and then released to them. Next, what happens in the probate process? Are you guys loving the probate process? Put a 1 in the chat if you're loving the probate process so far. I want to see some 1s. Oh yeah, I'm loving probate. Now why would you put a 1? Now you know.
Shakisha, before we move to another subject,
-1.
Just a quick point of clarification about what happens if you fail to name a personal representative. So does the law itself sort of as a default prioritize certain family relationships?
Yes.
So like, does the spouse have precedence over children or vice versa?
Now that's the thing. A spouse does have precedent over minor children or children, but not adult children, at least not in the state of Maryland. So a spouse and adult children can have the same priority. So you can imagine in a blended family where the spouse who died has adult children. Those adult children are not the adult children of the surviving spouse. You can imagine. Do you guys want to hear a story? Because I have another story about that. I mean, I have stories for days, everybody.
Please, a story.
There was a story. There was a surviving wife, and then there was the oldest daughter of the person who passed, and then there was the youngest son who was also an adult, but the siblings had different moms. So you had 2 adult siblings with different moms, and then you have a surviving wife who's not the mother of either of the surviving children. That court hearing about who was going to be the personal representative, a mess. The oldest daughter eventually got it. She was able to convince the court that she was the one most responsible, but it was a mess. Okay. So the -1 is the most accurate thing I've seen. That -1. Yeah. So yes, it does have a priority, but the problem is that people assume what the priority list says. And so surviving wife was a little surprised that her status as personal representative could be challenged by adult daughter. You guys want to hear another story? Of course you'd love to. So here's another story. 2 surviving daughters of the father, both of who had different moms, surviving wife. Now, surviving wife had been the wife through the birth of the surviving adult daughters who were not hers. So everybody reading what I'm putting down? Everybody picking up what I'm putting down? Okay.
Yeah.
They were not her children, but he had been her husband when the children were born. Okay. So she goes to court to go to be the personal representative. And she tries to tell the court that those children are not actually his children. So both sides spend thousands of dollars just to prove that they are his children. Never mind that they were all at the hospital together. But once he passed, she went and told the court that they're not his daughters. So now her and the lawyer of the oldest daughter were now co-personal representatives because no side trusted each other to get authority and share. I have more parables in the Bible. Listen, don't you make fun of me. Okay, I've been doing this for a few years now. I'm just telling you all, these are all okay. When this, oh my goodness, when this case, I worked at the firm where this case was going on for 5 years. The case started before I worked there and was still going on when I left.
Wow.
When that case is over, the lawyers might be making more than the beneficiaries. I'm not gonna lie to you, because they argued so much, because the father didn't have a will to just say, here's what happens, here are my kids, here's who gets what.
Yeah,
All right.
and it's not, sorry, go ahead, Ron.
Just quick, I'm just curious, what happens to the assets and things while it's pending in probate?
Nobody gets anything. I mean, that case had so much more to it, but nothing got distributed. It was just bills stacking up because there was property in multiple jurisdictions to sell. The wife tried to create a fake operating agreement for the business so that she could be the one in charge of it, and so she could sell it and get the money for herself and not for the girls. Whew, it was a -2. I'm not gonna lie to y'all. It was a -2. It's still going on. I could look up the case right now and tell you guys what's going on, but I won't do it.
Wow.
All right.
I just one follow-up question. So just because the father was married to this woman and he had children, it's not presumed that the entire estate, because she's his wife, goes to her essentially. It can.
Great question.
Okay.
Great question. She gets a statutory portion of the estate because DC, Maryland, some other states, they have a statutory a portion of the estate that goes to the surviving spouse.
Automatically.
Yes. There's like an allowance that goes to the surviving spouse. And then there's like a statutory amount of the net estate when I get down to property division and distribution, because I haven't even gotten there yet. When we get there, there's also a statutory amount that goes to them.
Okay.
Yeah. Yeah. All right. So we've only gone through bond, everybody. So you've gone through bond, kids, now creditor notification. If your estate goes through the court process, your personal representative will be required to publish that you have passed. Depending on the jurisdiction, it could be one newspaper, it could be two. So it could be anywhere from $15, depending on where you live, to $500. Right? So that's more money. And in that creditor notification, there's a statutory amount of time that creditors have to file claims against the estate. There's two things happening here. There are known creditors, which you have to notify by law. You can just go to them. Hey, they died. I know they owed you money. I need a final bill. Then there's unknown creditors, and that's what the publication is for. And when I tell you that these companies have algorithms, I don't care how small town the newspaper is, they will find out that it has been published that someone has died and they will send a bill. Okay. Certain people always send a bill. The hospitals always send a bill. The credit cards always send a bill. Utilities always send a bill. All right.
Wait, sorry. What's the difference between a known creditor and, like, can you give me an example of a known creditor as opposed to a non-known creditor?
You know that someone has a credit card, and as you're going through the mail, you see an outstanding credit card bill. You now know that they owe a credit card bill. It's a known creditor.
Yeah.
So it's not really anything the court can prove, but it's just one of those things that's just about the integrity of being a personal representative. It's a big duty.
Okay.
right? If you know that my mama owed so-and-so $5,000, but I mean, they didn't file a claim. I'm like, well, you just told your lawyer. So now we need to notify them.
Okay.
Known creditors. All right. Then after they have the time to file, so for example, in DC, they have 6 months. Now, what does that mean? Nothing can happen in those 6 months. You can't give money to the family in those and we're not even to the property division yet. Is everybody paying attention? This is all in order. Okay. Those debts have to be paid. So if it is a valid debt, it must be paid first, because probate is getting control of the assets, paying off debts, distributing the net estate. So the debts have to be paid. If there's no money after the debts have been paid, then you have what's called an intestate estate, meaning the estate has no more money left. And so you file with the court to tell the court that the estate is insolvent. Okay. And then if it does have money left, then the net portion of the estate gets to be divided. If you don't have a will, it's according to the law. And if you do have a will, it's according to your will. That is probate. In between all of those things, depending on your jurisdiction, you have to make reports at every stage. So you have to do an inventory. What does the estate own and how much is it, down to the cent? And then you have to do an accounting. What have you done with the money, down to the cent? That is probate. It takes at least a year to a year and a half to get through. So when we talk about the cost of probate, it can be anywhere from the cost of publication to whatever the amount of the debt repayment is, to balloon to the amount of how much it costs for the lawyers. So there really is an unlimited cost to probate. You could empty out someone's estate just by dealing with the court. And if you decide to get tricky and try to avoid it, the court will find it somewhere, somehow, they will find it. And so it is not a fun process to go through. And so when we do estate planning, a good estate planner is going to help you to avoid probate first and foremost. And how do we do that? We recognize that your will is not enough.
I have one question for you, Shakisha, before we
Yes.
keep going. Samara asked, if you have the privilege of a long life, is it reasonable to cancel all credit cards after all debt is paid off toward the end of life?
No, you don't have to cancel them. You just have to not have a debt to them.
Okay.
They don't, just because they're open, having an open credit card account is not the problem. Having a credit card account with an outstanding debt, that's where you have an issue, because credit card companies will come to collect their money. And if there is something that has been accrued after the date of death, they will not charge you for that, because that means that somebody used your credit card or something like that. Yeah. Great question though. All right. So
I have one question too, Keisha, to interrupt. I'm just curious, is another benefit to having a will that the person who passed away has taken the time in advance to identify all of their assets? Like, is there ever a situation where you might have hidden assets that an estate would be unaware of? And so,
yes.
Okay.
I won't tell you another story because we've got too many slides to go through, but yes, there have been situations where I'm just going to tell you a story. So this woman passed, her brother came to us. It was just her brother, and their two parents. They were all much older. So she was in her 60s, her brother was in her 60s, their parents were in their 90s. They were very private people. He was like, we didn't have any problems, but we were very private. So my sister died and I don't know what she owns. How am I supposed to find it? I said, well, there are services you can pay for that cost thousands of dollars to find all the assets. You can look up, their last IRS filing to get started. You can call their job to see what benefits they had, but that's a lot of footwork and a lot of time. And sometimes it costs a lot of money. So one of the benefits of planning your estate, whether you do a will or a trust, is that your will or trust should include a schedule which identifies all of the things that you own. That way, when it's time for people to wrap up the affairs of your estate, they know what to do. They know where you have your life insurance. They know where you have your retirement accounts. They know where your bank accounts are. I mean, it's really hard for people to find out where people's bank accounts are without calling each and every bank and just asking if so-and-so has an account there. So that is one of those things that happens when you're planning your estate, is that you're identifying what is part of your estate.
Yeah, thanks for addressing that. I think that's critical for our community, because those types of things aren't always openly discussed. And then there are also assets that are held abroad that you may or may not know that your parents own, or your aunt or your uncle, whomever. So it's that's definitely a benefit to will
Yes.
drafting.
And you should know, got another story, is that sometimes what the state will do is, if it's left there for long enough, it is escheated, which means that whoever is holding the account now gives money to the state fund. And depending on who your governor is, or who, you know, if you're, I don't know what the foreign laws are related to this particular thing, but in the states, depending on who your state is, who your governor is, and what they've decided to do with the budget, now money that you would have loved to leave to your family that your family couldn't find now goes to the state and is used in a way that you may never have approved of, because you're now out of control of that, right? You've lost the opportunity to make a decision about that. And I do have a story where someone was, they thought that their sibling had an account. And so we were looking everywhere, and finally, because they had paperwork that said there was an account in Philly. The person was a Maryland resident. There was an account they had in a Philadelphia-based bank that was like $40,000. So they're like, I just don't know where it is. And I said, have you checked the state's escheatment fund? And he said, I never thought of that. I said, well, how long ago did she die? And she had died like 10 years ago. I said, check it, because I think it could be there. And when he went, he found $45,000. They hadn't spent the money yet, so they gave it back to him. We found it just in time, but it very well could have been gone by the time that he did that. And so they were very grateful, because $45,000 is not something to sneeze at. Now, they did have to pay our attorney bill, but certainly they got to take home more than what they had before. And there was peace because there was resolution related to that. All right. That's a great question, Rahel. Thank you. All right. So listen, your will is not enough. And I know people are like, what? But everybody says to do a will. Yeah, you should do a will. It's just that if you stop at the will, you're not finished. A last will and testament is absolutely a necessary component of estate planning, but it is not in and of itself sufficient to do efficient and effective estate planning. What do I mean by that? That means if you have a will, you should also have, at the very least, beneficiary designations. So don't have a will, but you don't have life insurance beneficiary designations, or they're so outdated that they're not in alignment with what you want to do. Don't have retirement accounts without beneficiary designations. Don't have a car without a plan about what's going to happen to the car. Don't have a house without a plan about what's going to happen to the house. There are so many things that are available to you beyond a will, which is why it's important that when you're doing estate planning, I tell people this, I am really hesitant about people who use online estate planning tools where you never speak to a live person. You just fill in information and then it pops out estate planning documents. You might have found a will that is accepted in your state, but you may have filled it out incorrectly. Or you didn't go and then check your beneficiaries to make sure it was in alignment with the plan that you had. I just talked to someone who decided, you know, in the last few years, like, this is what I've changed about what I want to do with my stuff. I'd like to do 40-40-20, because one of her kids is she's just not doing what she's supposed to do. They're all adults. So she's like, look, this is just where it is. So I'm going to leave her something because she's my kid, but I'm not leaving it equally because she will waste it. And so we talked about, she has a house, so she's going to leave her house to 2 of the kids. She's going to leave a portion of her life insurance to the other one. So it equals out to 20% of her estate. So all of these things go together. Now you can do a will with beneficiary designations, or you can do a will with trust. So let's talk about trust. There are 2 big categories for trust. This is what you need to know. This is the difference between a will and a trust. Remember, I said a will guides the management of your estate through the court process. First and foremost, you will see that both types of trust when created and funded properly, avoid probate. What do I mean by created and funded properly? I'd like to make an analogy to a house. There are many different types of houses, right? You got single family homes, townhomes, got condos, you got multi-unit structures. So you got multiple ways that you can create a residential situation. But let's say you buy the house and you never furnish it. You have not turned the house into the home. You just got walls and floors. You just got a house. You don't have a home. Your home needs people. It needs furniture. It needs art. It really needs plants, everybody. Bring the outside in, okay? Plants help you to breathe better. It cleans the air, especially snake plants, you see? Especially snake plants. I mean, it's very good. This right here is my little money tree. That's why it's near my computer. You guys get it, the money tree? Okay, all right. So you really want to make sure that how you treat your house is what turns it into a home. It's the same for a trust. Two things you got to do. You got to create the trust properly through an attorney. Do not create a trust through an online tool. It is too complex to do it without a lawyer. There's few things that I'm going to tell you. But I'm a lawyer, right? But you guys haven't even heard me say you must hire a lawyer for this, but you must hire a lawyer for this. You are thinking about doing a trust, you must use a lawyer, a competent lawyer who's going to create it and then tell you how to put your stuff into the trust, which is called funding it. All right. But they serve different roles. So let's talk about a revocable trust first, because this is the one that most people are going to use. It's created for the purpose of creating flexibility and decision-making for the person who's creating it. And then it's structured in such a way that you can create generational wealth for the people who benefit from it in future generations. What's so great about this trust is that you create it, you can manage it, so you maintain full control. So whatever you put in the trust, you have the same control over those things as you did before you put them in the trust. And you can change it anytime for any reason during your lifetime, as long as you are competent. Now, after you pass, it becomes irrevocable. And the things that you can do with a trust is just unending. It could become, it becomes irrevocable, meaning it can't be changed after you die. But let's say you've got a nice size life insurance policy and you want to make sure that it's used to fund education for future generations. All the money in this trust goes towards college. Whoever in my bloodline is going to college or grad school or trade school or two-year college or certificate program, they can use the money from this trust if they can't find the funding for themselves. And it exists as long as there's money in it. It's a really great tool. If you have minors, you got to use this tool. Irrevocable trust. Now I'm going to tell you, I'm going to say it's created to protect assets, and people are going to go, oh, great, that's why I want it. It's actually the one that people use the least, because using this type of trust, if you want asset protection during your lifetime, then that means you have to give up control of whatever you put in the trust. So the government just doesn't allow you to protect things without giving them a little something in return, right? So if you want to put something in here to protect it from claims, minimize taxes, the government goes, great, no problem. You don't get to manage it. And if you want to change anything about it, the people you've listed as beneficiaries must all unanimously approve of the changes, or you have to go to court and the court has to approve of the changes. So you lose control in this type of trust because it's irrevocable when you create it. So it is possible to change it, but it has to be through the court, or all of your beneficiaries have to agree. Now, just imagine you create an irrevocable trust to protect, some asset during your lifetime. Let me minimize my taxes. Let me avoid these creditors who want my stuff. And then you list your 3 kids as the beneficiaries. And then you fall out with one of your kids and you go, oh, I need to change this thing because you are just not acting right. Do you think that the kid that you fell out with is going to go, yeah, sure, you can write me out of the trust. I'll approve having less in the trust. No, they're not going to do it. So most people do the revocable trust. And if there are things that you want to create or protect, there are other tools that are available that we can do in conjunction with trust, or that we can protect a different way. right? But most people are going to do a revocable trust because what it does is it really creates the opportunity for generational wealth. Because in a will, when you do that property division at the end, it just goes out. You have no control over it. It just goes to whoever you've listed. But with a trust, you could give things out over time. This could be 5, 10, 15, 20, multiple generations over time. So if you have a house that's worth a lot, or if you have a life insurance that's worth a lot, or a retirement account that's worth a lot, you can use a trust to be strategic about how you give it to your family in future generations, or how you give it to your family over the course of time, right? Because wills don't let you do that. A will is a one-time shot. When the court process is over, everything goes out of the account at once. But if you want it, to hold it, to be strategic with it, to build wealth with it, then you use the trust to do that.
What's the role of a trustee in creating a trust or in a trust? And I've heard things sometimes that where people have this conception of like the trustee can just walk away with everything in the trust. And what are your, I don't think that that's true, but I'm also a property as a wills and trust person. So
I always want to ask people, where do you hear these rumors? Who is
Yeah.
telling you this? Is it the internet? Is it Google?
Yeah.
So there are 3 parties to a trust. The first is the person who creates the trust. That person is called the grantor. Sometimes it's called the trustor. Second party is the trustee. That is the person that manages what is in the trust. And then you have the beneficiaries who receive the benefit of whatever is in the trust. The grantor and the trustee can be the same person when we're talking about revocable trusts. So you can name yourself as your own trustee, which is why I said that if you controlled it before you put it in the trust, but you put yourself as the trustee, then you're controlling it while it's in the trust. And so because you have the unique position of being grantor and trustee, then you get to do what you want the same way you could do what you want with your stuff before. If you are a successor trustee, meaning you were not the grantor, but you were named as a successive manager of the trust fund, you don't get to do whatever you want. You get to do what the trust says you get to do. Now, what people may be confused by is sometimes someone who creates a trust, let's say I create a trust and at some point in the future, I give my daughter trustee powers after I have passed. If I've left her with discretion, if I say, you can do this and the trustee has the right to decide how that goes, then they have flexibility in their decision-making, but it all is according to what I say. I get to control how the trustee makes decisions, what they have flexibility on, what they don't have flexibility on. And so that's why it's important that when you're creating a trust, you work with an attorney, because they're going to work with you to show you what might make sense to be flexible on and what might make sense to be much more rigid about. It's all about the structure that you create. It's why sometimes when people are going house shopping, they ask a realtor. They go, hey, realtor, here are the things that are important to me about the house I want to live in. And a good realtor will turn that into the perfect home for you.
Thank you. That's helpful.
All right. Now, a lot of times when people are doing legacy planning and that kind of stuff, again, they have these creditor claims. And much of it, and I actually just had a conversation about it, much of it comes from their businesses. Well, I want to protect my personal stuff from my business stuff. And that's why we do business succession planning. It is a separate part of estate planning. It's separate from personal estate planning. Personal estate planning is powers of attorney, wills, trust. That's all for your personal stuff. But when we're talking about business succession planning, we're actually thinking about, one, what's the structure of your business? Is it a LLC? Is it a corporation? Is it a partnership? If it's a sole proprietorship, then that means it's not a business that's separate from you. So you can address that in your personal documents, because according to the law, a sole proprietorship, it's just like the person who created it, right? But if it's a LLC, then you would create an operating agreement that would do all of the things we do in personal estate planning in that agreement itself. If you have a corporation, then in the shareholders agreement, you would reflect those decision makings. What happens if I get sick? What happens if I die? If the business is sold, who gets what? If it's a partnership, it's in a partnership agreement. What happens if a partner gets sick? What happens if a partner dies? What happens to the business and the assets of the business, whatever the business owns, if all of the partners die? So when you're doing business succession planning, the first question is always, do you want your business to outlive you? So I don't know if you all remember, those of you who were at the first session, I talked about the fact that my parents own a laundromat. And so the question becomes, what's going to happen with the laundromat after my parents pass? Do any of us, their daughters, want to run the laundromat? I mean, I can tell you, daughter number 2 does not. Daughter number 3 likely does not. But daughter number 1 might want to. And so if that is the case, then we have to create a business succession plan so it smoothly goes from my parents to my sister. Because if not, that has to go through the probate process. So personal estate planning, like wills and beneficiary designations, trusts, those manage what happens to our personal things that we own and whether or not we have to go through probate. And for business, our operating agreement, our shareholders agreement, our partnership agreement, that controls whether or not we got to go to court to get legal authority to be able to do something. All right. So all of these things can work together. And so it's important that when we're thinking about what does it mean to make informed decision making? Do I need a will? Yes. Do I need more than a will? Yes. What that is depends on informed decision making. This is where you really want to sit with someone who can tell you, okay, based on what you have and what you want to do, you need your will, you need your powers of attorney, and we can just do beneficiary designations and you'll be good. Or they'll say, you have your wills, your power of attorney, and we need to do some deeds. Or you got your wills, you got your powers of attorneys, we need to add some trust in here. And this is the type of trust, and this is why it works for you. You really want to sit with someone. I mean, if there's nothing else I can tell you all, before you decide what to do, talk to someone about your particular situation, your particular needs, and let them tell you, based on their years of experience, based on their knowledge of the law, what it is you need. And then go from there. You need informed decision-making. These sessions give you broad information, but I can't give you specific information to you and your family and what you want to do. So you got to sit down with someone. There's nothing else you get from this. Schedule a consultation with an estate planning attorney who can tell you what is what you need for your particular situation, because the best gift you can give your loved ones after you die is a well-planned estate. If there's nothing else we have talked about the fact that when we are talking about operating in love, it's about making wise decisions, right? And so what that means is sometimes you need to have hard conversations, y'all. Sometimes you need to confront the things that nobody wanted to talk about, the things are swept under the rug, no longer doing it how it's been done for generations, but really making a decision that says, this is an act of love, not only for myself, but for the people I love. And so I'm going to do this hard thing because I love my people enough to do it. I don't want to make anybody feel guilty, but it is really important that you understand that doing estate planning is an act of love for those that you care for. And I'll get off my soapbox.
We have a question in the chat. Do you recommend joint wills over separate wills?
No.
For example, what would you recommend for a married couple?
Separate wills.
Well, there you go.
because unless you all die at the same time with exactly all the same stuff, it becomes confusing. Would you like to hear a story? Of course you would. A couple came to me and she was a surviving spouse, and the only will she had was the one that she and her late husband had together. And that will had already been probated in court. So we had to ask the court to accept the will again, but for somebody else where things looked a bit different. So I told her, the best thing for you to do right now, your late husband has passed, do your own will, because the decisions that you all made together, and when you made this will all that time ago, those things are not the same, right? So I advise you having separate wills. Now, what we do a lot of times for married couples is they'll do what's called sweetheart wills, where it's the They give everything to their spouse, and then they kind of agree on what happens after that. But yes, I do recommend separate wills over joint wills any day, because you just can't guarantee that you'll pass at the same time.
Great.
So the sweetheart, sorry, Naomi,
No, it's okay.
just a quick question. The sweetheart approach makes sense because then there's consistency between the husband and wife, or the two people in the marriage. But to the extent that they kind of go about it separately, right? Wife decides, I'm going to do my own thing. Husband does it on his own time. So what happens if there's ever any conflict between like jointly owned assets? How are they treated?
Question. I just saw the parables in the book of Shakisha. I'm going to take that. And you're going to have to tell me how to pronounce your name so I can give you proper accreditation. But what I would say is that if a attorney is working with a couple and finds that they are in a standoff conflict, then typically what the attorney does is that they remove themselves as representing them, or they choose one of the spouses. It's really how it has to go. Because if there is a conflict with them, so like I have my own caveat in my contracts, which is I am not the decision, I'm not the tiebreaker between the three of us. And don't tell me anything you don't want your spouse to know, because I'm snitching. All right. The confidentiality exists outside of the three of us. Between the three of us,
Right.
There's no secret. There's no secrets. All right. Now, have I had a spouse come to me and do their estate planning and their other spouse did not? Yes. Like, just because a spouse comes to me doesn't mean I'm going to go tell your spouse you're now doing estate planning. That's different. A spouse can come to an estate planning attorney on their own. And in fact, it happens quite frequently because, especially in communities of color, I hate to say it, but like the wife will come and will tell us that her husband doesn't want to do estate planning. Excuse me. But it is so necessary for her to do something because it's weighing on her. And so, yes, there are situations where one person in the married couple will do their estate planning and the other will not. I've seen it done.
Great. Any other questions? We're also gonna, I wanted to just remind everybody that we are working on a toolkit that we will send out to everyone after these workshops. So stay tuned for that. And then additionally, right now I'm just putting the Google Forms, like a quick little survey. If you want to just give us your feedback, it helps us plan for future workshops, as well as try to do, well, we're not going to do anything better at this point. We've done a pretty good job. So
You guys are pretty awesome.
so, but yeah, if you have any feedback for the future, just, let us know. Another question, anonymous attendee. Once all the documents are prepared, do you advise there should be a family meeting for all parties involved to be notified?
Absolutely. Okay, so let me just tell you why. It is what I recommend. It is not required. But remember, we are talking about efficient and effective estate planning, which means if there are people who are key to your process that have not been informed that they are key to your process, your estate planning will not be effective, because now after you pass or after you get sick, people find out that they have a role to play. The other thing is that sometimes, especially if you know that you have family members that don't have the strongest relationships, or people who may be disappointed by decisions that you're making. Now, ultimately, it is your decision. And so if you think that it's going to cause a situation where it's going to get really, really messy and violent for your own mental health, you don't want to address it, fine. That's on the beneficiary side. But as it relates to those who will have a role in your estate planning, someone who's going to be named as an agent in your durable power of attorney, someone who's going to be named as a proxy in your healthcare power of attorney, someone that you have named as a personal representative or executor or as guardian of your children, yes, please tell them. Please make sure they know. I will tell you that from experience, some people find out things after people have died and they're not really great with it, but the person has passed, so who are they going to complain to? I mean, I'm just saying, like, there's some people who like feel I have to give something to so-and-so because they're my kid or whatever. As a parent, I hope that my relationship with my daughter does never get to the point where I don't want to leave her something. However, if it does get that way, I am not required by law to leave her anything unless I don't do my estate planning documents and then the law says you're next in line. But if I'm doing my own estate planning, I get to decide who gets my stuff. I don't know if you all remember, anyone who's in the first session, I told you all my parents have 3 children. If they decide not to leave me anything, that is their right. And, because I'm an estate planning attorney, I'm not actually going to have any feelings about it, because if there's anybody who understands that you get to decide what happens to the things you worked hard for, it's going to be me. Now, as a first generation daughter of immigrants, I just don't see them cutting me out, because honestly, I'm really funny. I go to every Sunday dinner. I'm the parent of all of their grandchildren. So, well, actually they might skip me for my kids.
Funny.
It might be my sisters and my kids getting everything, but that's fine too. I'm cool with that. I'm an adult. I can take care of myself.
Any
I
other?
think- I have a question to piggyback off the person who just submitted that question. That was a great question. So where's like the best place to store a will, or is there like, how do you, especially if you're going to make multiple iterations of a will, right? You're constantly updating, or a trust, or even the LLC documents, these things that are all privately held, they're not required to be registered anywhere. What's the best way to go about it so that they're working off of the latest version when you pass?
Yeah, excellent. So one, that's why it's important to name. That's why it's important to communicate with those who have a key role so that they know if it's been updated or anything like that. Number 2, typically estate planners, once you've signed them, they will be able to give you an electronic version of your signed documents. But number 3, I tell all my clients, fireproof, waterproof, safe, and tell one person you trust the code. Some people also use safe deposit boxes. I'm not the biggest fan of safe deposit boxes, especially if you've had it for like more than 30 years. We had to hear a story, here it goes. We had a client who had a safety deposit box in a place, and it had been there so long that a new bank had come in and they built a wall over the old safety deposit boxes. So they had to drill into the wall of the bank to get to the old safety deposit boxes to get the stuff out of it. So I'm not the biggest fan, especially if you've had it for, decades. But what I tell people is, okay, if you're going to have a safety deposit box, make your personal representative, your executor, an authorized user, or, have authorized access to it. Because if you can't find the safety deposit key, and all that kind of stuff, there's a lot that you have to go through. So fireproof, waterproof, safe for your original documents. Save it. I actually have a USB that I carry in my wallet that's password protected. So in case I'm traveling and I need to access them, I got it right there with me. We now have the cloud, so you can save it in the cloud, password protected with the folder, right? So you have a lot of options. And specifically for the will, wherever you live, you can actually file your will at your courthouse. And it usually costs something nominal, like $5. And then if you update it, you can just file the update as well. But that's an easy place to put it, because then if anybody has to go to court, the will is already in the system and it'll be flagged.
We have a question from Winta. She said, in a scenario that I am the only beneficiary to my parents' assets, and say a friend is a beneficiary to mine, if I pass, does the friend also get parents' assets?
Assuming that the parents pass first, right? The friend gets all of the assets that are in the person. The beneficiary gets all of the assets in the person's estate. So whatever is in your estate at the time you pass, they get those assets. So if your assets at the time you pass include stuff from your parents, then yes. But I wouldn't say they get your parents' assets. They just get yours. Do you understand the difference?
Yeah.
I wouldn't still call it your parents' assets when it becomes yours. I would just call it yours. But if you're worried about succession in that way, and that is something that we talk to families about, that is another reason to use a trust. So if someone has a trust and I say, my stuff goes to my daughter, this is especially important for people who don't want assets to go to in-laws. Okay. All right. So let's say that I leave stuff for my daughter and I say, if my daughter passes, then all the stuff that I left for her goes to her kids, because I don't want it to go to her spouse at the time, who could then remarry, which then goes to their spouse.
Yeah.
Right. So if you want to control the succession of your own stuff, then it's great to have a trust to hold it in.
Okay, so basically, if she would pass first, which is what she's asking, then and she has a proper estate planning document, like a will, and she passes, then the assets from her parents
Let me take it
would
from
pass to the friend now.
Got it. No.
Okay.
Beneficiaries only get what, so the decedent is the person who died. I just need to say that because I'm going to use that word. Beneficiaries only get what's in the decedent's estate.
Okay.
So just think of it that way. So if it's not in the decedent's estate, the beneficiary doesn't get it. The
Okay.
beneficiary only gets what's in a particular decedent's estate where they've been named as the beneficiary. So for example, if I name a beneficiary, and this is why most estate planners will name successor beneficiaries. If I say my car goes to my friend and my friend dies before my car goes to them, then what's in my estate planning documents as to what happens if something doesn't go to my friend, that's what controls. If I die before my friend, then she gets my car, it's now her car. And so whatever is in her estate planning documents is what happens to the car. So a beneficiary only gets whatever a decedent has named for them in that decedent's estate. If it's not in the estate, it doesn't go to the beneficiary.
So if her parents haven't died yet and she hasn't received their assets, it does not go to the friend.
Exactly.
Now, in the event that her parents do die after she has passed and the friend has collected the assets, would then the parents' assets transfer over to the friend now?
Only if the parents' assets would only go to anyone the parents haven't named if they've already moved into someone else's estate. Does that make sense? Let's just use a car as an example. Parents own a car. Daughter is named as beneficiary of the car. If daughter dies first, daughter doesn't get the car. So whatever was daughter's estate over here, let's say daughter's estate has a paper. And when daughter dies, it just has the paper. Right? If she dies before the parents, it just has the paper. So whoever is the beneficiary of daughter's estate just gets the paper. If parents die first, now daughter's estate is paper and car. So when she dies, whoever are her beneficiaries get paper and car. So I don't like to skip, right? It's not, does the friend get the parent stuff? It is, what does the friend get from the daughter's estate? Okay. Whatever is in the daughter's estate when she dies. It's the only way. The only way the friend gets the parent's assets is if the friend is in the parent's estate plan.
I see. And she can't be in the parent's estate plan through the daughter designated.
Someone else's documents? No.
Okay.
I can't put in my estate plan who benefits from my parents. That's not under my control, right? That's why I said separate wills, because ultimately what's in one person's estate is what happens to one person's estate is what is governed by that person's estate planning documents. No one else can control what happens in my estate. Okay. It's not mine once I die and it goes to someone else. It's not mine anymore.
Okay. Nitsiti had a question. What is the best type of trust to set up for your parents so that they can continue to receive government funding, healthcare, or other assistance if needed, without fear of losing their home and other assets?
Great question. It depends. It depends on what kind of government assistance they're receiving. It depends on if they're receiving it already. It depends on when you're going to seek receipt of it. So if they are not receiving it because they are unqualified to receive it, they have too much money, like Medicaid. We'll use Medicaid as an example because that usually is the biggest one. So if they want to receive Medicaid and they're not receiving Medicaid because they're ineligible, then people will use a type of irrevocable trust to put the parents' assets in it. Remember I said anything that goes into an irrevocable trust is no longer under the control of the originator. The caveat to that is that Medicaid looks back 5 years. So if you move it into the trust and then apply the next day, they're going to see you moved it into the trust and penalize you. But if you put it in the trust and then you apply 1 day after 5 years of putting it into the trust, they won't see it. It doesn't exist to them. So it all depends. If they're already receiving benefits because that's, they qualify for it, then you could use a revocable trust because they're already qualified, right? But the caveat to that is that there are way more questions I would need to ask. Like I need to get into finances for the parents, and I need to understand what someone means by establishing a trust for their parents. Do they really mean paying for the lawyer who will then work with the parents to establish a trust? Because you can't establish a trust and tell someone else to put their stuff in it. You see what I'm saying? So so tell me what you mean by that. Do you mean you're just going to pay for the attorney to work with the parents? Because it's the people creating it who have the control. If you're creating it, then your parents never had any control over it because it's your trust. So that's why I gotta.
So if you're creating it, so if like, let's say you're helping your parent pay for the lawyer to create the trust.
Then under that situation, there are questions I have for the parents because frankly, kids don't always know what their parents have.
Yeah.
So I'd have to ask the parents what the finances look like, what the debts look like, what the assets look like, before I can tell them what's the right trust for them.
Got it. And then, I followed up and said that, primarily it's because we're assisting our parents with like language barrier issues. And so we would probably be present. Yeah.
Understood. But that means we're really operating as an interpreter.
Yeah.
Because at the end of the day, every decision has to come from the person who has the authority to make it. So one of two things has to happen. You're just interpreting and your parents are still the ones making the decisions, or your parents have named you as their power of attorney so you can speak for them. But not, and now I see what you're saying. Yeah. And yes, listen, when we go to, I'm gonna use a simple example. We go to restaurants and my cousin's mom is not talking to Americans. She's just not doing it. She's not eating the menu. She's not doing any of those things because she don't go out. She cooks. So she's like, what are you taking me out for? So she will talk to us in Patois about what she wants to eat and we will order for her. So, right, we're the interpreter for her, but ultimately she's still deciding what is happening. We're just information with the person who's going to make it happen.
Yeah. Okay. Yeah. I think the reason is because I think a lot of us, right, ultimately end up managing like the affairs of our parents in different ways, whether it's Medicare or like managing whatever. So we step in these ways. And so I think culturally that especially like, like the older people in different families, older kids get kind of swooped in with this. But
if I can just say this as someone that all the Jamaicans come to. For those of you who are in the Eritrean American Bar Association, if you are considering other areas of law that may be of interest, estate planning is a wonderful area of law. You get to spend time talking to people. You also know that because you understand the culture of the people that you're serving, you can serve them best with the legal know-how that you have. Like I serve foreigners better than all my American estate planner friends because there's stuff I understand about our culture that they just don't get. It doesn't matter how much they read about it. They just don't get it. But when we talk about like getting down into the nitty-gritty, I know best about Jamaicans.
Yeah.
I know best about Caribbeans, but I really know best about Jamaicans.
Yeah.
I really know best about Black foreigners, right? So I just want to encourage people in the Eritrean American Bar Association. Is this thing on? Estate planning is a wonderful and profitable area of law with great work-life balance. So If you are interested in this area of law, please reach out to me so I can convince you how great it is. Join me.
Are you talking to me?
I know. Who are you talking
And
to?
Naomi.
Was I
Naomi's
looking
lawyer
at your
too.
little, was I looking at your little square while I was talking? Perhaps I was. Rahel, you'd be an amazing estate planner.
Oh, that'd be great. That would be great, Rahul.
Only if Naomi and I can open up shop together. That's the condition.
Yeah, I'm not smart enough
so
for estate planning, but you know.
y'all talking. Okay, so we're talking about a partnership here. Let's talk
Yeah.
about it. Okay, let's talk about it. I'm not kidding. This is such a wonderful area of law, and it is special that I can do this. I am absolutely an honorary Eritrean. Absolutely,
welcome.
absolutely. I love you all's food. Please invite me to the next gathering. Absolutely. I'm vaccinated.
Absolutely. You're more than welcome. Somebody else had a question that said, once assets are titled / funded in a legal document, if there's a loan balance that the beneficiary is responsible for the deficiency balance or on assets like a house, car, RV, etc.
Okay. Excellent question. Excellent question. Generally speaking, beneficiaries are not responsible for the debts of someone who has died. Remember, decedent is someone who has died. A decedent's estate is responsible for a decedent's debts. Caveat, there are some debts that are attached to assets, right? So if a mortgage is attached to a house, the mortgage doesn't care who the owner is. The mortgage just wants to be paid. So when you're thinking about stuff like that, that means that decisions have to be made. So that's why I like to make sure that when we're thinking about estate planning, this is the cultural responsiveness, right? Is I will ask, is there still a mortgage on the house? Yes, there's a mortgage on the house. Okay. Who do you want to give the house to? I want to give the house to my daughter. Okay. Can your daughter handle the mortgage that's on the house? Well, actually, no, because here was okay. Yeah. So can we get a life insurance policy that's in the amount of the outstanding mortgage? So that and give her the house, you also give her the balance for the mortgage. So you give her a house free of a mortgage debt. Do you see what I'm saying? Yeah. These are conversations that a culturally competent, a human-centric estate planner is going to have with you that these online programs just are not. Yeah. So yes, that's a great question. There are some debts that stay with the asset. And when there are debts that stay with the asset, we need to be careful and we need to plan properly about what it looks like to take care of that debt. That could just mean that when the reason why we want the house to immediately go to the kid is because what they can do is they can refinance the debt to something that is a more manageable payment. So it just requires a conversation and then proper planning around it.
Thank you. And then Samara asked, broadly speaking, are family members allowed to interpret or do professional interpreters need to be involved for estate planning documents?
I err on the side of if you think that someone will have trouble reading a legal document, then yes, give them what they need to help. Right. It's the same thing as, because an interpreter, I mean, you can have like a official interpreter, I guess, but it really just is a matter of, is there someone who can help the family member to understand what is happening? That's really the estate planner's goal. Okay. So if it is a matter of the estate planner hiring someone who can interpret, because let's say that if it's one child, but not another child, one child is going to accuse the other child of like improperly, influencing the parents, then we might just hire an official interpreter to do it. Okay. But I've definitely been in situations we've had Spanish interpreters who have come in, and sometimes we just have additional family members like kids or whatever, which is up to the right of the person creating the estate planning documents because they feel more comfortable have someone there. If it's the kid, I had a estate planning client, his mom brought him to every meeting because that was the son that did everything for and with her. She was American. She understood everything that I said. She was sharp as a whip. But because it was her son who managed everything for her, She had him at every meeting. It was her choice. So she and I talked separately, and she said, I want him at every meeting. And I said, that's your choice. You remember, the confidentiality is held by the client. So they get to make a decision about who is at the meetings and when.
Great. Thank you. So that we'll wait a couple more minutes, at least another minute here for any additional questions that anybody may have.
Yeah, while we're waiting, Shakisha, how often should we be updating our wills to account for like new assets or life events and things like that?
Great question. How often should you be updating all of your estate planning documents? You should be.
Thanks for correcting me, not just my will, but the comprehensive toolkit. Yes, the entire thing.
Yeah.
So the typical timeline we tell people is 3 to 5 years. And that's just because typically every 3 to 5 years, something has changed, right? Shakisha, I am out of sight, out of mind kind of person. So I tell people that when you sign your estate planning documents, I tell them to open up their phone. Today is your estate planning signing anniversary. Make a reminder yearly on your phone, and on your anniversary, take some time to take a look over everything. Because what that does is, for somebody like me, it puts it top of mind. Because I don't want you to buy a house within the 2 years and you forget to tell your estate planner. So now your estate planner has to do extra work to get it into your trust if you have it. Whereas if you said to your estate planner, hey girl, I just want to check in. I'm about to buy a house. Anything I need to know? Oh, we planned for this in your trust, but just make sure when you go to signing, they sign it over to you as the trustee. That's what the deed is in, not to you as an individual. And now we don't need to do any extra work. Now you don't have to pay me extra money to get it into your trust. So it's that building relationship. So whatever's going to work for you, but definitely not longer than that 3 to 5 year range. Because I mean, so much has changed. Like I look back listen, I keep forgetting the pandemic was 3 years, but I mean, just imagine what your life was on March 1st, 2020. And now think about your life as of March 1st, 2023. Probably looks a little bit different.
Absolutely.
Somebody tell me how to pronounce that.
It's still Shakisha.
Yeah, that's how he spelled it.
Yeah, it's just spelled out phonetically.
Yeah.
We could have a whole conversation about the complexity of our alphabet.
Love that. Thank you. I feel very welcome. Invite me to the cookout. I don't know what you all call the cookout.
He called it the guayla, which is basically like a big old party. Yeah.
Is that the cook? See, I'm ignorant. Invite me to the guayla, please.
Yeah,
there you go.
We have an Independence Day party coming up, so we're gonna make sure to send you an invite. I will be in
town, so if I don't get a text from Rahel, then I will.
There's an email coming. Don't worry.
Sure you get it. Yeah.
You guys, did you forget about me? I thought you said I could come.
You're definitely gonna be there.
Yep. So we're gonna send this out. Shakisha, thank you very much. There's no more questions. I cannot describe how grateful I am that you have helped us through this whole entire process. It has been incredibly just beautiful, and you're dope. There are no words. I think it's amazing the way you present. Like, this is an area of law when you study for the bar that is extremely freaking complicated. I did not have a good wills and trusts professor in law school, but I have now definitely learned wills and trusts, and I'm very grateful for you for that. And so thank you so much. And
very welcome.
I hope people should also share love to her in the chat. Please do that. Like, please check her out. Please go to her website. She's amazing. And let me just say, she has taken 3 weekends to literally do this for us for free.
Yeah. More than that if you count the planning time.
Yeah. Like, even taking time to meet with us beforehand to prep for this, it's really a gift, and I really appreciate it from the bottom of my heart. Like, I think it's a gift that you've given us, and I really appreciate it, and I'm very grateful to you, and I know other people in the community are as well. So thank you very much.
The best repayment you all can give me is to go find someone to sit down and talk about your estate planning with.
We're definitely going to do that now, for sure.
Yeah. You scared us straight.
For the toolkit, everybody.
Yeah. Well, thank you very much. And please, everybody, fill out the survey, follow Eden and the Eritrean American Bar Association. We're very grateful that you all have joined us for this series. Rahel, I don't know if you have anything else you'd like to add.
I just wanted to echo Naomi's sentiments. Thank you so much, Shakisha, for delivering this awesome presentation. Not only was it informative, but it was culturally sensitive, which is really critical for our community where there can be language barriers or just disparities in knowledge, right? Because we're first generation, just like you. And so thank you for translating this in layman's terms, for empowering us to use the information, not just in setting up our own estate planning, but helping our parents and, paying this backwards and forwards. So for our future generations and past generations. So thank you. Thank you. Thank you.
Thank you
Thank
for
you.
having me.
Thank you, guys. All right. Thank you, guys.